Ladies and gentlemen, here we are. It's Friday and I am triggered. I shouldn't be. I just came back from a nice little off-the-grid trip to Mount Rainier. No Wi-Fi, no cell service, and I was surprisingly good with it. But then, I came back to this shit. I shouldn't be surprised. The TSA is on my short list of triggers. Them, along with SJWs, fake prankers on YouTube, and resort fees should be avoided.
The usual suspects.
Just like epileptics need to learn how to avoid flashing lights, I need to learn how to avoid any mention of the government getting its slimy little fingers into anything to do with travel. And in the case of the TSA, that's not figurative. So what exactly are we dealing with today? Let's hop in our DeLorean and travel back to 2006. Business consultant Nadine Pellegrino was traveling to Florida from Philadelphia when the TSA singled her out for some invasive screening. She objected and requested a private room. The TSA agents complied, but during the exam, Pellegrino requested the TSA agent replace her glove, as she believed them to be dirty. The agent again complied but was apparently annoyed. At this point, Nadine claims they started treating her and her luggage roughly. In protest, Pellegrino told the screeners they were behaving like bitches. From here, Pellegrino claims she was falsely accused of striking the officers, and she was subsequently arrested, held for 18 hours, and charged with aggravated assault, possession of instruments of crime, reckless endangerment, simple assault, and making terroristic threats. Whew. Worth noting is that she was found not guilty at the trial the following year. For her troubles, the consultant sued the TSA for $951,000. Wow. Now, what exactly happened during this exchange is anyone's guess. She was probably mad at the fact she was singled out, the TSA agents were probably mad she was complaining, and they both likely postured up, assuming one was the other's boss, and in private, the agents probably got grabby, she probably got pushy, one thing leads to another, egos are bruised, and she winds up in a cell. I'm just guessing here, because the facts of this particular case don't really matter. What is important, however, is the language contained in the majority opinion issued by the 3rd U.S. Circuit Court of Appeals when dismissing the case. In a turtle shell, they said, "We're the government, we're just doing our job, and that means you can't sue us." So that's why I said the facts previously mentioned don't matter. Because even if the TSA agent was Voldemort and turned the passenger into snake food, they'd still be off the hook when it comes to civil liability. Central to the issue at hand is the FTCA, or the Federal Tort Claims Act, a whole steaming pile of government, one aspect of which limits the extent that non-law enforcement officials, aka administrators, can be sued. It takes it down to about nothing, provided they can claim they were just doing their job. Of course, nobody should be surprised, as any bureaucracy's true goal is self-preservation, the US government being the largest example of this in the world. In their decision, the court held that TSA officers did not qualify as law enforcement personnel and were therefore entitled to qualified immunity, even if the acts were intentional. Further, the court noted that the TSA does not conduct criminal searches, only administrative ones. Apparently, in the eyes of the majority sitting on the bench, form is more important than substance. So long as they've self-identified as civil, they're free to do what they want. There was, however, a small glimmer of hope. A dissenting opinion offered by Judge Thomas Ambrose. He noted that what TSA officers do is not much different than what police do every day. He further noted that the majority's opinion would effectively bar passengers from seeking redress, even in the most extreme cases, such as the one regarding TSA officers in Denver that were accused of manipulating security procedures so they could grope attractive male passengers. Sadly, however, this nugget from the bench only serves as comforting words, as they form the minority opinion. Though I, and many others, have grown used to the fact that judicial opinions often seem to exist outside of reality, I'm still surprised by the sheer number of citizens who still seem ready to line up and submit, provided the government claims it's in the name of safety. Take these specimens, for example. First, we've got Josh Stabich, who smugly proclaims,
"Good. Every whack job has been trying to whine about the TSA lately. You're in a sealed tube 6 miles above the earth with hundreds of people you don't know. I don't care what they do.
Josh, your opinion is incorrect. This line of reasoning has been used to justify countless government atrocities over human history. As long as they're not doing it to me, or we all need to suffer a little bit in the name of safety. In Josh's world, he's more scared about his fellow passengers, the ones with near unlimited liability, than he is about the government agent in blue, the one who's just been told to grope away and you're off the hook. Next up, we've got D, proudly announcing,
Good! You can't have cops, security, TSA scared to do their job for fear someone's feelings get hurt.
Wrong on so many levels. First, you're conflating the role of law enforcement and the TSA, something your government just expressly separated, the basis for the court's entire opinion. Strike one. Second, we're not talking about people's feelings getting hurt, we're talking about warrantless searches of innocent people, something the Bill of Rights is supposed to protect. Strike two. Finally, you're hiding behind the picture of a horse. At least have the decency to present yourself when offering these oppressive opinions. Strike three, your opinion is out. So, just to recap, the TSA can now grope, assault, arrest, or do whatever they want to you, and you have no recourse. Even the court's majority opinion confirms this, specifically saying, we recognize that our holdings here, combined with our decision in Venderklok, mean that individuals harmed by intentional torts will have very limited legal redress. And I'll leave it at that. I do feel a little better getting some of that out. So to whoever is watching, thanks. As per usual, if you happen to agree with today's pLOG, a like, share, or subscribe is appreciated. If not, go ahead and crush that thumbs down button, and we'll see you tomorrow.